Hello, law students and legal professionals. Today, we will delve into the case of Christian Cadajas y Cabias versus People of the Philippines, GR number 247348, and decided by the Supreme Court on November 16, 2021. Doctrine of the case: child pornography is committed when a person induces, persuades, or coerces a minor to engage in the production of sexually explicit materials, regardless of any claimed romantic relationship or the private nature of the material. A minor's consent, whether express or implied, is legally immaterial due to the inherent power imbalance between adults and children. Republic Act No. 9775, as expanded by Republic Act No. 10175, treats child pornography as malum prohibitum. Proof of inducement or persuasion suffices. Intent to commercially distribute or publicly disseminate the illicit material is not required. The law is preventive in nature and aims to protect minors from sexual exploitation in all its forms, including those committed via electronic communication. The Supreme Court also ruled that the constitutional right to privacy protects individuals mainly against intrusions by the state, not against acts of private individuals. Thus, evidence obtained by a private person, even if taken from a messaging or social media account, does not automatically violate the constitutional right to privacy and is not rendered inadmissible per se. In this case, the messages and images were obtained by the minor victim's mother, a private individual, not by law enforcement authorities. Hence, the exclusionary rule did not apply. The court further held that a person who voluntarily gives access credentials to another cannot later invoke a reasonable expectation of privacy over the data accessed through that consent. Lastly, the court clarified the interaction between the Data Privacy Act of 2012, RA 10173, and criminal proceedings. It held that the processing and use of personal data are allowed when necessary for the determination of criminal liability and for the protection of lawful rights and interests in court proceedings, both of which are recognized exceptions under the law. Facts of the case: Christian Cadajas y Cabias, petitioner, then 24 years old, became acquainted with AAA, a 14-year-old minor, when the latter visited the establishment where he was employed. What initially started as a casual interaction eventually developed into a romantic relationship despite AAA's minority and petitioner's full awareness of her age. Their relationship was largely maintained through Facebook Messenger, where they communicated frequently over an extended period. At the outset, their exchanges were ordinary and conversational. However, these gradually escalated into intimate and sexually suggestive discussions. Petitioner deliberately steered their conversations toward sexual topics, sending messages with lewd and explicit undertones. He cultivated an environment that encouraged AAA to reciprocate such communications. Over time, petitioner exploited AAA's vulnerability and immaturity by persistently inducing her to engage in sexualized behavior online. He repeatedly requested that AAA send him photographs of her private parts. Influenced by petitioner's continued prodding and emotional manipulation, AAA eventually complied and transmitted to him images of her breasts and vagina through Facebook Messenger. The illicit relationship was discovered when AAA's mother, BBB, accessed her daughter's Facebook account. Upon reviewing the message exchanges, BBB uncovered the sexually explicit conversations as well as the nude images sent by AAA to petitioner. Shocked and alarmed, BBB confronted the situation and explicitly warned petitioner to cease all communication with her minor daughter. Despite this warning, petitioner willfully disregarded BBB's directive and continued to communicate with AAA through the same online platform. His messages remained sexually suggestive, demonstrating his persistence in maintaining the inappropriate relationship. Recognizing the gravity of the situation, BBB took steps to preserve evidence by securing screenshots, printouts, and copies of the Facebook Messenger conversations, including the explicit messages and images. These materials were later submitted to authorities and formed part of the prosecution's evidence. A criminal complaint was thereafter filed against petitioner. During trial, petitioner admitted that he had sent sexually suggestive messages to AAA but denied having sent nude photographs of himself. Notwithstanding his denial, the prosecution presented substantial evidence, including the documented online exchanges and testimonial evidence, establishing that petitioner knowingly and intentionally induced a minor to produce and transmit sexually explicit images. The Regional Trial Court, RTC, found that all the elements of the offense were present and convicted petitioner of violating Section 4, c. 2, of Republic Act No. 10175, Cybercrime Prevention Act of 2012, in relation to Anti-Child Pornography Act. Issue and ruling of the Supreme Court. Issue 1. Whether petitioner is criminally liable for child pornography despite claiming that the acts were consensual and done within a romantic relationship. Yes, petitioner is criminally liable. Section 3(b) and Section 4(a) of Republic Act No. 9775 criminalize the inducement, persuasion, or coercion of a child to engage in the production of pornographic materials. Section 4(c)(2) of Republic Act No. 10175 extends liability when the offense is committed through computer systems. Jurisprudence consistently holds that minors are legally incapable of consenting to acts that result from adult inducement, persuasion, or influence. The Facebook messages clearly showed that petitioner actively coaxed and induced AAA to send explicit images of her private parts. Regardless of AAA's apparent willingness or the existence of a sweetheart relationship, the law deems this consent immaterial. The petitioner exploited the minor's emotional immaturity and susceptibility, precisely the harm the law seeks to prevent. Issue 2. Whether the crime imputable to petitioner requires proof of commercial intent or public distribution of the child pornography. No, commercial intent or public distribution is not required. Republic Act No. 9775 penalizes child pornography in all forms, including private possession and production, without distinction as to purpose or scope of dissemination. The law recognizes that sexual exploitation occurs even when materials are created solely for personal viewing. Petitioner's argument that the images were intended for private use is immaterial. The offense was consummated the moment petitioner induced the minor to create and transmit sexually explicit images. The absence of a commercial motive does not absolve criminal liability. Issue 3. Whether petitioner's constitutional right to privacy bars the admission of Facebook Messenger conversations as evidence. No, the right to privacy does not apply in this case. While the Constitution protects the right to privacy of communication, such protection does not extend to criminal acts or evidence lawfully obtained by private individuals. Evidence voluntarily accessed by a parent from a minor child's account, without government intrusion, is admissible. The messages were accessed by AAA's mother using her own device and were not the result of unlawful search or seizure by the state. Moreover, the state's paramount duty to protect minors overrides privacy claims arising from illicit online conduct involving children. Issue 4. Whether the prosecution proved petitioner's guilt beyond reasonable doubt. Yes, guilt was proven beyond reasonable doubt. Conviction requires proof that 1. The victim is a child, and 2. The accused induced, persuaded, or coerced the child to engage in the creation of pornographic material. Direct evidence is not indispensable when circumstantial evidence forms an unbroken chain leading to the accused's guilt. The age of AAA was undisputed. The explicit Facebook messages, petitioner's admissions, and the actual transmission of sexual images conclusively showed inducement. Taken together, the evidence satisfied all elements of the offense beyond reasonable doubt. Thank you for listening, and happy learning.